Hello, welcome to another important topic of corporate law. Today's topic details the meaning and importance of shares and share capital. It will also inform about the various aspects of transfer and transmission of shares. In addition, the lesson also explains the various types of shares. Difference between shares and stock is also something we study today. I'm Amrita Ghoshkumar, and the subject expert for this lesson is Dr. S. Miraj, who is teaching in the Amity University. We will begin with a broad overview of the concept of shares, transfer and transmission and stock. A share simply represents an individual member's interest in a company. The total value of a company's shares is called its share capital. Shares are either usually held in public limited companies or private limited companies. These shares give a member certain rights. For example, may give a right to a dividend and voting rights within the company. The nature of those rights depends on the class of share and what has been specified in the Articles of Association. A minimum of one share must be issued at incorporation, and a company can alter the value of the share capital, issue further shares and cancel shares, although the latter can be difficult. From October 2009, the new Companies Act no longer requires companies to have an authorized share capital and maximum level of share capital that it may issue, although it may still choose to set a maximum level if it wishes in the Articles of Association. Companies can issue shares on the basis that payment will be taken and called for at a later date. That is either known as called up or uncalled share capital. The total value of all paid shares is called paid up share capital, although most shares are generally issued fully paid. Capital refers to the amount invested in the company so that it can carry on its activities. In a company, capital refers to share capital. The capital clause in Memorandum of Association must state the amount of capital with which the company is registered, giving details of number of shares and the type of shares of the company. A company cannot issue share capital in excess of the limit specified in the capital clause without altering the capital clause of the MA. The following different terms are used to denote different aspects of share capital. 1. Nominal, authorized or registered capital means the sum mentioned in the capital clause of Memorandum of Association. It is the maximum amount which the company raises by issuing the shares and on which the registration fee is paid. This limit cannot be exceeded unless the Memorandum of Association is altered. Number 2. Issued capital means that part of the authorized capital which has been offered for subscription to members and includes shares allotted to members for consideration in kind also. Number 3. Subscribed capital means that part of the issued capital at nominal or face value which has been subscribed or taken up by purchaser of shares in the company and which has been allotted. Number 4. Called up capital means the total amount of called up capital on the shares issued and subscribed by the shareholders on capital account. That is, if the face value of a share is rupees 10, but the company requires only rupees 2 at present, it may call for only rupees 2 now and the balance rupees 8 at a later date. Rupees 2 is the called up share capital and rupees 8 is the uncalled share capital. Number 5. Paid up capital means the total amount of called up share capital, which is actually paid to the company by the members. In India, there is the concept of par value of shares. Par value of shares means the face value of the shares. A share under the Companies Act can either be of rupees 10 or rupees 100 or any other value which may be fixed by the memorandum of association of the company. When the shares are issued at the price which is higher than the par value, say for example, the par value is rupees 10 and it is issued at rupees 15, then rupees 5 is the premium amount. That is, rupees 10 is the par value of the shares and rupees 5 is the premium. Similarly, when a share is issued at an amount lower than the par value, say rupees 8, in that case rupees 2 is discount on shares and rupees 10 will be par value. Shares in the company may be similar, which means they may carry the same rights and liabilities and confer on their holders the same rights, liabilities and duties. There are two types of shares under Indian company law. Number 1, equity shares means that part of the share capital of the company which are not preference shares. 2, preference shares means shares which fulfill the following two conditions. Therefore, a share which does not fulfill both these conditions is an equity share. One, cumulative or non-cumulative. A non-cumulative or simple preference shares gives right to fixed percentage dividend of profit of each year. 2, redeemable and non-redeemable. Redeemable preference shares are preference shares which have to be repaid by the company after the term for which the preference shares have been issued. Irredeemable preference shares means preference shares need not be repaid by the company except on winding up of the company. However, under the Indian Companies Act, a company cannot issue irredeemable preference shares. In fact, a company limited by shares cannot issue preference shares which are redeemable after more than 10 years from the date of issue. In other words, the maximum tenure of preference shares is 10 years. The shares may be redeemed out of profits of the company which otherwise would be available for dividends or out of proceeds of new issue of shares made for the purpose of redeemed shares. If there is a premium payable on redemption, it must have provided out of profits or out of shares premium account before the shares are redeemed. When shares are redeemed out of profits, a sum equal to nominal amount of shares redeemed is to be transferred out of profits to the capital redemption reserve account. This amount should then be utilized for the purpose of redemption of redeemable preference shares. This reserve can be used to issue of fully paid bonus shares to the members of the company. Number 3, participating preference share or non-participating preference shares. Participating preference shares are entitled to a preferential dividend at a fixed rate with the right to participate further in the profits, either along with or after payment of certain rate of dividend on equity shares. A non-participating share is one which does not provide right to participate in the profits of the company after the dividend and capital has been paid to the preference shareholders. The difference between shares and stock is that shares are transferable only in complete units, so that transfer of half or any portion of share is not possible, whereas stock is expressed in terms of any amount of money and is transferable in any money fractions. Articles may be giving the board of directors authority to fix minimum amount of stock transferable. Since stock is not divided into different units, it is not required to be numbered. Shares, on the other hand, must be numbered. A company limited by the shares or a company limited by guarantee and having share capital can, if authorized by its articles, by special resolution and subject to confirmation by the court on petition, reduce its share capital. It may effect reduction of its share capital in any of the following circumstances. 1. Where the company is overcapitalized. A. It may extinguish or reduce the liability of member in respect of uncalled or unpaid capital. For example, where shares are of ₹100 each with ₹60 paid up, the company may reduce them to ₹60 fully paid and thus release the shareholder from the liability on uncalled capital of ₹40. B. Pay off or return part of the unpaid capital not wanted for the purpose of the company. For example, where the shares are fully paid of ₹100, they may be reduced ₹40 each and ₹60 may be paid back to the shareholders. C. Pay off part of the paid up share capital on the footing that it may be called up again. If shares are of ₹100 each, the company may pay off ₹25 per share on condition that when desired, the company may call it again without extinguishing the liability of shareholders to pay the uncalled share capital. Number 2, where the company has suffered loss of capital, in such situations the company can write off or cancel the share capital which has been lost or is unrepresented by available assets. 3. Where the company has passed the resolution for reducing the share capital, it must by petition apply to the court in the prescribed form to the court for an order confirming the reduction. Reduction of capital can take place without the sanction of the court in the following cases. A. Buyback of shares in accordance to the provisions of section 77A and 77B. B. Forfeiture of shares. A company may, if authorized by its articles, forfeit shares for non-payment of calls by the shareholder. Such proceedings amount to reduction of capital, but the Act does not require court sanction for this purpose. C. Valid surrender of the shares. A company may accept the surrender of shares. D. Cancellation of capital. A company may cancel the shares which has not been taken up or agreed to be taken by the person and diminish the amount of its share capital. E. Purchase of shares of members by the company under section 402B. The Company Law Board may, on application made under section 397 or section 398, order the purchase of shares or interest of any member of the company by the company. These provisions come in force when a prescribed number of members make a complaint to the CLB for mismanagement or oppression of the minority shareholders in the company. F. Of redeemable preference shares. Where redeemable preference shares are redeemed, it actually amounts to reduction of the capital. However, this does not require the sanction of the court. G. Buyback of shares. Buyback of its own shares by a company is nothing but reduction of share capital. After the recent amendments in the Companies Act 1956, buyback of its own shares by a company is allowed without sanction of the court. It is nothing but a process which enables a company to go back to the holders of its shares and offer to purchase from them the shares that they hold. There are three main reasons why a company would opt for buyback. 1. To improve shareholder value, since with fewer shares, earning per share of the remaining shares will increase. Number 2, as a defense mechanism against hostile takeovers, since there are fewer shares available for the hostile acquirer to acquire. A company may purchase its own shares or other specified securities out of 1. its free reserves, or 2. the securities premium account, or 3. the proceeds of any shares or other specified securities. No buyback of any kind of shares or other specified securities can be made out of the earlier proceeds of an earlier issue of the same kind of shares or same kind of other specified securities. No company can purchase its own shares or other specified securities unless the buyback is authorized by its articles, a special resolution has been passed in general meeting of the company authorizing the buyback is of less than 25% of the total paid up capital and free reserves of the company. The buyback of equity shares in any financial year shall not exceed 25% of its total paid up equity capital in that financial year. The ratio of the debt owned by the company is not more than twice the capital and its free reserves after such buyback. However, the central government may prescribe a higher ratio of the debt than that specified under this clause for a class or classes of companies. All the shares or other specified securities for buyback are fully paid up. The buyback of the shares or other specified securities listed on any recognized stock exchange is in accordance with the regulations made by the Securities and Exchange Board of India in this behalf. The buyback in respect of shares or other specified securities other than those specified in clause G is in accordance with the guidelines as may be prescribed. Every buyback must be completed within 12 months from the date of passing the special resolution. A company may issue shares at a discount, that is at a value below its par value. The following conditions must be satisfied in connection with the issue of shares at a discount. A. The shares must be of a class already issued. Now, B. Issue of the shares at discount must be authorized by resolution passed in the general meeting of the company and sanctioned by the company law board. C. The resolution must also specify the maximum rate of discount at which the shares are to be issued. D. Not less than 1 year has elapsed from the date on which the company was entitled to commence the business. E. The shares to be issued at discount must be issued within 2 months after the date on which issue is sanctioned by the company law board or within extended as may be allowed by the company law board. F. The discount must not exceed 10% unless the company law board is of the opinion that the higher percentage of discount may be allowed in special circumstances of case. A company may issue shares at a premium, that is at a value above its par value. the following conditions must be satisfied in connection with the issue of shares at a premium. The amount of premium must be transferred to an account to be called share premium account. The provisions of this Act relating to the reduction of share capital of the company will apply as if the share account premium account were paid up share capital of the company. Bonus shares are issued by converting the reserves of the company into share capital. It is nothing but capitalization of the reserves of the company. Bonus shares can be issued by a company only if the articles of association of the company authorizes a bonus issue. Where there is no provision in this regard in the articles, they must be amended by passing Special Resolution Act at the general meeting of the company. Care must be taken that issue of bonus shares does not lead to total share capital in excess of the authorized share capital. Otherwise, the authorized capital must be increased by amending the capital clause of the Memorandum of Association. If the company has availed of any loan from the financial institutions, prior permission is to be obtained from the institutions for issue of bonus shares. If the company is listed on the stock exchange, the stock exchange must be informed of the decision of the board to issue bonus shares immediately after the board meeting. Where the bonus shares are to be issued to the non-resident members, prior consent of the Reserve Bank of India should be obtained. Only fully paid up bonus shares can be issued. Partly paid up bonus shares cannot be issued since the shareholders become liable to pay the uncalled amount on those shares. Sweat equity shares mean equity shares issued by the company to its directors and or employees at a discount or for consideration other than cash for providing know-how or making available the rights in the nature of intellectual property rights or value additions. A company may issue sweat equity shares of a class of shares already issued if the following conditions are fulfilled. A special resolution to the effect is passed at a general meeting of the company. B. The resolution specifies the number of shares, the current market price, consideration if any, and the class of employees to whom the shares are to be issued. At least 1 year has passed since the date on which the company became eligible to commence business. Transfer of shares by the operation of law is known as transmission of shares. Transmission of shares takes place in case of death, insolvency or insanity of members of the company. In case of transmission of shares, there is no need to fill the transfer deed. On the happening of any of the above events, that is death, insolvency or insanity, the shares are transferred to the legal representatives of shareholders. The legal representatives may also differ depending on the existence of will of the deceased partner. If the deceased shareholder has left behind any will, then the shares will be transferred to the person mentioned in it. In the absence of such will, the transfer of shares will be made in favor of the legal heir of the deceased member. Official receiver or official assignee becomes the legal representative of insolvent member. In case of insanity of shareholder, his guardian becomes the legal representative. As legal representative is entitled to become the member of the company, he files an application to the company for the transmission of shares on his name. He may also choose to sell the shares instead of becoming a member of the company. Let us now quickly summarize all what we have learned today. We have learned that a share simply represents an individual member's interest in a company. The total value of a company's shares is called its share capital. Shares are either usually held in public limited companies or private limited companies. These shares give a member certain rights. For example, may give a right to a dividend and voting rights within the company. The nature of those rights depend on the class of share and what has been specified in the Articles of Association. Capital refers to the amount invested in the company so that it can carry on its activities. The difference between shares and stock is that shares are transferable only in complete units, so that transfer of half or any portion of share is not possible, whereas stock is expressed in terms of any amount of money and is transferable in any money fractions. Transfer of shares by the operation of law is known as transmission of shares. So, that's it for today. We will see you with another topic of corporate law very soon. Till then, take care.